My name is Amanda Teo. I use she, her pronouns. And on behalf of our faculty director, Diane Canstrom, our assistant extraordinaire, Abigail Chingo, and the Rappaport Center, we welcome you to this panel today. So for those of you who I have not had the pleasure of meeting, I am the new executive director for the Rappaport Center. Thank you. There is going to be a time when I will no longer introduce myself as the new executive director, but today is not the day. Today is not the day because I get to share the room today with my predecessor, Lizzie Medwidow, who you know OG-ED. So Lizzie is the Martin Sheen to my Jenny Smiths. She is the Steve Carell to my Ed Helms, or God forbid, Jim Spader. The Kristen Chenoweth to my Ariana Grande. She is the original and the best. We really miss you, Lizzie. So thank you for being here. Says a lot about Lizzie's commitment to the center and what we do, that she is here to support and engage with this panel. So with that, the most important thing I have to say is that this panel is being recorded. So put on your best selves. This is a very special panel for me, not only because this is the first panel I'm introducing as the new executive director, but also because the issue of survivor advocacy is very near and dear to my heart. I know those of you who were here last time before Hema's community address heard Professor Canstrom's very generous introduction of me. I was counsel to the United States Attorney and Chief of Staff of the Suffolk County District Attorney's Office. Before I took on those leadership roles, I spent close to a decade as an appellate prosecutor, working primarily with survivors of domestic violence, sexual assault, child exploitation, and homicide. And I was drawn to that career because I watched a lot of it. Sam Waterston taught me English as an immigrant. But also because probably like every one of the hardworking, generous, and committed former colleagues that I had in the DA's office, I wanted to quote unquote help victims. And as a young prosecutor, sometimes I'd say things like, my work was to quote unquote speak for the victim. And as I stand here now, that makes me cringe. And I cringe for so many different reasons, many of which are going to be talked about by the panelists that we have here today. But most fundamentally, I cringe because nobody needs or wants to be spoken for. And when I was an assistant United States attorney in the civil rights unit at the U.S. Attorney's Office, I carried a sticky note on my laptop when I went to interview women who had been trafficked or prostituted. And who then suffered further abuse at the hands of the Worcester Police Department. And that note had on it a line from psychiatrist Judith Herman. Professor Herman, in her book, Trauma and Repair, wrote, survivors of violence who know in their bones the truth that many others would prefer to not know can lead the way to a new understanding of justice. The first step is simply to ask survivors what would make things right, or as right as possible for them. This sounds like such a reasonable thing to do, but in practice, it is hardly ever done. And here's the line that I had on my sticky note. Listening, therefore, turns out to be a radical act. And I think a lot about that line because I think a lot of us today are thinking about what is the radical act that we can do as lawyers, as practitioners, as law students, in the midst of everything that is going on around us. And so that brings me great joy to introduce this panel because these are folks who have turned this radical act of listening to survivors into everyday practice, into their careers, into their life mission. And I have the honor of introducing our moderator, and then our panelists are going to introduce themselves. Our moderator is Hema Sarang-Sieminski, who is the executive director of Jane Doe Incorporated, the Massachusetts Coalition Against Sexual Assault and Domestic Violence. At JDI, Hema has directed strategic legislative and systems change efforts and led efforts to shift the field's reliance on criminal legal and other punitive systems. Hema has been a leader in this field for over 20 years. She has served as an attorney at the Victim Rights Law Center at the Network of Red and in the Immigration Unit for Greater Boston Legal Services. Most importantly for us today, she is our Rappaport Senior Fellow. We are overjoyed to have her and to be inspired by her today, as we were last week at her community address. So everybody, please welcome Hema.
Thank you all so much. It's so great to be with you all once again, and especially after this week that has truly felt like a year plus, many years. But I am brought back to this sense that we started touching on last week, that there is so much potential and opportunity to really craft strong, protective, inclusive local policy and practices and make systems change right here. And it is such an honor to be here with this incredible panel today to really highlight a couple areas of work that are really in the space of emerging or leading edge issues in survivor advocacy. Each panelist today will be introducing themselves and helping us understand different facets of what it takes and who it takes and the labor involved in doing that kind of policy creation work that is survivor-centered and responsive to the needs of the most vulnerable to both sexual assault, intimate partner abuse, human trafficking, other forms of intimate harm, but also to the intersection of other forms of state violence as well. So this is gonna be a great conversation. So I'm gonna let our panelists kick it off. I'm gonna turn to Lisa first, and let's have you, Professor Goodman, talk a little bit about what it means when we talk about domestic abuse or intimate partner abuse. Oftentimes, like we talked about last week, there can be a limited understanding of what that looks like. Our media still has a very particular portrayal of harm as very much rooted in physical violence. But we know that the dynamics are so much more, or we are growing as a community and knowing that. And we'd love to hear your, have you share a bit more about that?
Thank you so much, Hema. It is such an honor to be here with you all. I'm surrounded by lawyers in my life and in my family, and I like you guys. I'm a psychologist. I'm in the in the Lynch school. Normally, and I've been doing work with survivors for 30 years and research, which I can describe if it's of interest later on. But okay, where's my friend here? You promised I would just press the button. Because I'm a teacher, I don't do much without a PowerPoint. So what I want to do with my very brief initial remarks is to follow up on Hema's question, what does intimate partner violence really look like, and how is it experienced by survivors? I think that in the law, traditionally, it has been understood as discrete acts over a very restricted period of time. So we asked survivors, how many times did this happen? What type of violence did you endure on your body? And what that does is reveal the very tip of the iceberg, but leave invisible the broad pattern of domination and control that is often, not always, but often present, that really strips survivors of their agency and autonomy, making coercive control sometimes described as a liberty crime. So I want to just in my 3 minutes describe what is beneath the surface and what coercive control is really like. And this is based on quite a bit of research. So at the core of coercive control lies a set of demands backed by credible threats. The demands there's infinite numbers of demands that a harming partner can make on a survivor, about their personal appearance, how to cut your hair, how to look, where to go, how to cook dinner, how to keep the house clean, how to parent the children, work and finances, whether a survivor can work, and if so, where, what time they have to be back, who they have to hand their paycheck over, usually to the harming partner. That's called economic abuse. Sexuality, can be entirely coerced. And can involve forced pregnancy and, many other aspects of sexuality. That only matters, of course, and a demand gets its teeth from the credible threat that underlies it. And those threats can be, I'll hit you again, and it doesn't take much physical abuse to make someone fear it, right? So it doesn't, the physical assault doesn't have to occur yesterday for someone to fear it today. But it can also be other kinds of threats that really rely on an exploitation of the particular vulnerabilities of the survivor. So one could weaponize a survivor's attachment to their children. I will try to get custody of the kids a lot, even if I've never expressed any interest. It can exploit, at this present moment especially, their undocumented status. I'll report you. There are psychiatric challenges. I'll steal your meds and then I'll try to get you committed. And all of these things, and I can talk about this more later, of course, are reinforced and supported by social structures that allow it, don't stop it, and even support unwittingly a harming partner's threats. So eventually the threats don't even have to be articulated to be omnipresent, kind of like a loaded gun that's over there. You don't have to look very hard to know it's there. And then there's a bunch of other tactics that reinforce this basic demand threat and that instill fear and diminish a survivor's sense of self. These can include, well, first of all, surveillance. How does the harming partner know the survivor is obeying the demands? They can stalk, digitally stalk, physically stalk, use tracking devices in cars, video cameras inside the house, outside the house, asking third party, demanding the third parties report on the survivor. And eventually, psychologically, this comes to feel like the harming partner is omnipresent, kind of like a panopticon, anywhere and always watching. Degradation, like insulting, humiliating, shaming a survivor, intimidating them by creating all kinds of instability, and unpredictability can wear down a survivor and eventually make them feel sort of worthless, ashamed, and terrorized and hypervigilant and on guard, which makes them then vulnerable to the remaining tactics, which can include deprivation of basic needs, so that the survivor is sort of like on alert, really just trying to get there and their children, if they have any basic needs taken care of, and don't have the bandwidth to think about what is happening to them and how they can address it. Isolation is sort of at the core of coercive control, either as a harming partner can demand that the survivor stop seeing other people, embarrass and humiliate the survivor so much in public that it's sort of a choice to let go of relationships, or threaten people in a survivor's network to the extent that they are afraid of having contact with the survivor. And ultimately, the survivor, without any input from the outside, can feel like there's nowhere to get help, and what is happening is sort of normalized, because there's no voice saying this should not happen to you. And then there's manipulation of perceptions through gaslighting. I did not hit you yesterday, I don't know what you're talking about. Or blame shifting. Yeah, I hit you, but I had no choice because of the way you were acting. And these things can kind of further narrow a survivor's ability to perceive reality as it is, even to the point where the survivor starts to trust the partner more than themselves. And that is, sort of become the point of coercive control in some ways. So ultimately, all of these tactics, and there are more, which I think we might get into soon, kind of limit a survivor's what we call space for action, both psychologically and practically. They are more and more and more limited in their capacity to think and act. Less and less possible, therefore, to tell anyone, to reach out for help, either from people in their networks or from formal agencies, or leave. And so that ultimately people that we see will have managed to overcome some of that, to reach out at all. It is a monumental display of strength to be able to get out from that web, to be able to share even a little bit. And I'll report again.
So I'm Jamie Sabino.
I was gonna just say, thank you so much for that. As we move to the next question that I think you could really build upon, Jamie, is with that grounding, what is the sort of legal landscape and policy landscape, both past and present, that is really informed by this evolving definition? That'd be really helpful, so. thank you.
Yes. So I'm Jamie Sabino. I am the Deputy Director of Advocacy at a place called Massachusetts Law Reform Institute, which is a statewide poverty law center that does impact legislation, litigation, advocacy, and provides support to legal service attorneys in the field. And my particular area is family law and domestic violence. All the legal service lawyers in Massachusetts who do family law, all the cases involve domestic violence. I've been there 10 years. And prior to that, I was at the trial court for about 13 years, handling how the trial court handled domestic violence. And before that, I was in two-person general practice for 23 years, doing a lot of family law, but also representing criminal defendants, wills for all my uncles, a whole variety of things. I'm going to touch a little bit on that later to talk about how you too can be involved in this area without having to work for Jane Doe or get a full-time job working with domestic violence. I want to just give 4 examples to back up what Lisa was talking about, and then go into the current legal landscape. Both coercive control changes in our current law, and a little bit about the second look that people are starting to talk about more, and the criminalization or other victimization of victims of domestic violence in other institutional areas. That look, many clients would say, oh, he'd get that look. And that's, and I remember that's how he looked before he beat me up 10 years ago. One person telling me, an advocate saying, the woman got the restraining order and then leaving the court, and the guy says, I'm going to the truck. What did that mean? That's where he kept the guns, on the truck. So just saying, I'm going to the truck, terrorized that woman. Tracking. Remember my client saying, it checks my mileage. When I go to the grocery store and come back, mileage to make sure that's the only place I went. And the gaslighting, for those of you who probably heard the term and might not know, it comes from a movie called Gaslight, in which the abuser is trying to make the woman believe she's crazy, and part of it is changing the gas, which makes the lights go on and off. What's modern day gaslighting? Nest. Nest is a way that you can control things in your house. And we have credible reports of people whose temperature can be in their house, can be done remotely. And it's like, all of a sudden the house is really hot and then it's cold and I might go crazy. So there's this whole range of ways that this works. Up until this past year, to get a restraining order, you had to show physical abuse, attempted physical abuse, even reasonable fear of physical abuse. And for many clients, that was difficult, particularly because judges would say, well, you say he hit you 5 years ago, but you stayed with him. You must not have been afraid. And why are you afraid now? Why are you coming to court now? The clients themselves would talk about what's the worst thing, like calling the C word in front of my children. It's not for 15 or 20 minutes, or maybe the next meeting that, oh, he broke my arm. Because what's in the front of their mind is the emotional humiliation that captures their everyday life. And even the physical abuse, you used to say, for who want to change it unless there was blood, that wasn't enough. So the restraining order was changed in Massachusetts, and it can now be for incidents of a pattern of coercive controlling behaviors. And I'm going to let Anne talk a little bit about how we organize that. And it was the voice of the survivors that made the difference. I had not thought I would see that law happen in my lifetime. And I was getting a little worried because that period of time is getting shorter. But in about one session it passed, and that was because the legislature heard the voices of the survivors. And that's what made the change. And changing that in that statute, we're hoping it's going to have a ripple effect. So that coercive controlling understanding will move into other areas in which domestic abuse survivors interact. And I'm going to talk about 3. Well, who knows? One is the criminal sphere. Many women who are currently in prison are also survivors of domestic abuse. And we've heard about, you're all young, so you may not have seen. Back in the 1980s and 90s, there was this group of women called the Framingham Eight, who were in prison for having killed their partner or husband. And in those cases, they were all victims of domestic abuse. And self-defense was like, well, if he's hitting you, you can hit him back. Or if you're in very life, you can use that. But not like, I've had this lifetime and I'm going to shoot him now before he does anything else. And that kind of, they used what the battered women syndrome was not admissible in court, and many of these people either took plea deal or were convicted. The Framingham Eight were a group of women who were serving on life at Framingham, and through the Women's Bar Association, a group of lawyers took on these cases, and in some of them, they got commutations of the sentences, or a new trial to add, to be able to bring up these kinds of offenses. That has morphed a little bit now into a broader second look for people who are in prison and have now been rehabilitated or no longer a threat. And it's not all people who are there for life, but they've been in prison for a certain period of time. A lot of those people are victims of domestic violence. And the criminal activities often came from the fact they were coerced and intimidated. Drug use and drug trafficking, prostituted women, other things that discipline of the children. Well, I did it because they said I had to hit the kids. A lot of women, and I will refer you back to a woman named Maureen Morton Hawk, who is a professor of sociology at Suffolk School of Law, who did a lot of research, and back in 2004, published a paper called Pathways to Prison. And the vast majority of the women who were living in prison had drug use, mental health illness, and domestic violence. And even for the drug use and mental health illness, a significant number, I can't remember the statistic, but we're talking a vast majority were victims of domestic abuse. And it was never really looked at how that interacted with their incarceration, their criminal victimization. And I believe those issues are important in second look laws. About 14 states, I can't remember now, that have these second look laws. And I can imagine making an argument that I'm rehabilitated, and in fact, the reason I committed this crime was because I was a victim of abuse. And now, the person wasn't good, but I've been away from this person and I'm not going to fall back into it. So I think that's incredibly important. Many women who are involved in their families have mental health issues, substance abuse, and are victims of domestic abuse. And that I'm going to get your kids can be custody, or I'm going to call DCF on you if you kick me out of the house. And that's a significant concern. And unfortunately, with a lot of young social workers, they don't have enough understanding. It's, you told me that you're a victim of domestic abuse. You're not protecting your kids from me. Why didn't you leave? You need to go get a restraining order, even though that might be the most dangerous thing for that person to do, get a restraining order. So there are many women in DC. If you look at the probate and family court and cases where women have made allegations of domestic abuse, it is often turned against them, that you're making that up because you're trying to cut dad out of the kid's life. You are now a parental alien. And incredible research done by Joan Meyer and the George Washington 704 TV stuff. It's got some formal name, but if you just Google Joan Meyer, you'll find her work they do that when there's evidence of domestic abuse or sexual abuse of children and claims of parental alienation, more often than not, the parental alienation wins. So we're hoping that it's hard enough. It was hard even to say, oh, there wasn't domestic abuse, but there wasn't good. There weren't medical records. You're just making this up. We're hoping that introduction of coercive control into 209A. In fact, there's now a statute that lays out, I'll get examples of economic abuse, status abuse, personal autonomy. Will make it easier for people to recognize that they are survivors, be able to speak about it, and hopefully that the systems will understand that a little bit more. And so before I go, I would say how you two can be involved in this. If not that and issues of reproductive justice, which is what I do as a sideline. People say, oh, I want to be a reproductive justice lawyer. Well, there are 10 of those jobs in the state. Get involved in your local bar association. And most of them have programs. In Massachusetts, the Women's Bar Association and the Women's Bar Foundation, which does the pro bono work. And Lucy Medvedev, who you all know from the Rappaport, was the executive director of the WBOW for years. We in 1993 created something called the Family Law Project for battered women. Now it's the Department of Violence, where people are trained and mentored to be able to take cases in family court of people who are survivors of domestic abuse, particularly when there are custody issues. But these are lawyers who are corporate merger and acquisition lawyers and real estate lawyers and lawyers who just say, well, maybe I want to do family law and this is how I can get training. And they're able to do this work through participating in the Bar Association. Volunteer Lawyers Project is another example where people can volunteer through pro bono work. And let me tell you, that is not only fulfilling, but it opens a lot of doors. Maritza Connolly, who teaches at Suffolk and runs their family law clinic, had been a corporate lawyer who took the case through the Women's Bar Foundation and changed her whole practice. There's also opportunity to do elder law issues through this. And importantly, the WBF has a program for women reentry from prison, but also a clemency and pardons program, representing women in Framingham who are applying for pardons and clemency. So there are a number of ways that you can be involved in this without landing that great job as executive director of Jane Doe.
Thank you so much, Jamie. So much to dig into from that. You know, I think as we were putting this panel together, I was reminded of, I'm doing policy work, direct legal services work for so many years. And now in this role at the coalition, we talk about our work as really being survivor-led, and that to me, a commitment was really to move into policy work that is truly grounded in survivor experience and having survivor experience shape policy and not vice versa, right? And I would love, and by way of introducing yourself as well, I would love you to talk a little bit about this really monumental victory and what it took to build and organize a coalition of survivors and so many others that led to this law that, like Jamie said, we didn't imagine it would certainly never happen in one session, perhaps not even in a lifetime. So thank you so much and wanted to pass it to you.
So it's such an honor to be here. Thank you. It's so wonderful to be here in front of law students. Oh boy, we need you guys. Man, so we're with a Community Connections Coalition in Worcester, and we bring parents and providers together to address gaps in services. And we bring parents together to bring out their voices and help improve systems. And so our funding, strangely enough, is from Department of Children and Families. And as Jamie said, one of the top 3 things they find are domestic violence. So we brought some survivors of domestic abuse together, and they've been a wonderful group of most all women right at this time. And they are looking at different ways that they can speak up and improve the system of care. And then we heard about Jennifer's law in Connecticut, the death of that, I think of the last name of the woman. And it was very tragic, and they passed a law, coercive control. And I remember we were in our meeting thinking, we can do it, we can get that, how do we do that? And then again, praise God, just connected, I don't know how it happened with Jamie Sabino, happened to come to one of our meetings. And we talked about it and she said, yeah. And then she said, let's connect with Hema and Nithya and Jane Doe and boom. And it just came, well, that's the message. You can do this stuff. You can make big changes and it's all about relationships. So once we had mass law reform and Jane Doe, and they came together so quickly with support. And then there was Mass Families Advocacy Group led by very powerful survivors in Massachusetts. They came to the table. Jamie and Jane Doe brought them. And then we brought other leaders, were part of coalitions from across the state. And then boom, and boom. But I don't mean to say it was easy because you're forming a statewide coalition. And so in coalition work, there's something called norming and storming. And so we definitely had to figure out, we had a steering committee, our little steering committee group, how are we gonna plan meetings, who's gonna facilitate and who's gonna be on steering, and it's tricky. But I think we worked very well together, and so they got into different roles. And then we started having a regular monthly meeting of survivors. And I think that's the powerhouse as a survivors. I think my observation in domestic violence work, I think we can treat survivors as, don't touch them. They've been exposed to trauma, keep them in hiding, but they want to speak up, honey. And boy, they were the powerhouse behind this. And again, we have to do it responsibly. They're trauma survivors. We don't just, come to this meeting and share your story to expose yourself. So we really learned with the help of Jane Doe how to do it responsibly, preparing them if they didn't feel, Jane Doe did some wonderful trainings with, how do you share your story with legislators? If you didn't feel comfortable, anonymity, you don't feel comfortable, have someone else read your story. I think the other, I wrote down a couple of things that really made a difference. So we were very concerned about the fathers' rights groups hearing of this and coming after us. And I think it was Jamie and Armin Oliver, who's wonderful leader in our group, had side meetings with some of the legislators. And I think it was with Senator Eldridge, and they paired this bill we were going for with revenge porn. So it was kind of tucked in there. It was brilliant. Trying to think of some of the milestones. We just had to act very quickly. There were hearings, there were events at the State House, but we had such a strong group of people willing to chip in, jump in, and head to Boston as needed, collecting people's stories. I'm trying to think of some other highlights, and I'll let Jane and Hema kind of fill in.
Well, yeah, telling the stories, we had an over 8-hour legislative hearing on the courts control and some other bills, and there's still work that's left to be done around the use of litigation and coerced debt. And people told their stories, and they had like a 3-minute limit, which is very difficult for some people. It's difficult for them to say anything. They're limited, and there were a lot of tears, and it was very emotional. And I knew we were getting through when one woman was crying so hard she couldn't talk. And one of the legislators got off the bench, came down and held her hand while she finished telling her story. And I thought, well, at least we know that, Rep. Rockley gets this. And you could see the faces. There were, on these legislative hearings, there are people who get up and leave and come back. Why did people stay to that whole 8-hour hearing? So you know that they were listening to these voices and it was having an effect on them. The other thing about the statewide is, it's starting with this small, mighty group of women in Worcester, but it's like, oh, my sister lives in Springfield, I can call her. Or an advocate saying, well, I know the advocate from the Pittsfield organization would probably want to get involved. So it was kind of slow. It was challenging, however, to listen to the survivors' voices sometimes because they didn't want to talk. And as a lawyer, I talk all the time, and I have to keep saying, I've got to listen. I can't be the only voice at this meeting, and sometimes I felt like I was. But that's a good skill for any of the lawyers you do, listening to your client. It might be some corporate client you don't really give a shit about, but they care about this. And you want to know what they care about. You think they care about X, and they really care about Y. So learning to listen as a lawyer is the best skill you can do. It's also useful as a parent.
And it's challenging because I'll just say, as a social worker, so these survivors have been exposed to incredible trauma over years, it's been so well discussed. So they may come across as hysterical and very difficult to listen to the whole story. They, I'll let other folks share more, but it's a big jumble of years. And he did this, and do you know what happened? And they've been traumatized over years, so the patience to really sort it out. And as Jamie said, to listen and to take that extra time is so key to these survivors. But they may come across it at first as some of the most challenging clients in that way.
And that's why we made a good team, because we want to get to the meeting in an hour. I sometimes had to cut people off. But Ann had the lovely social worker voice that said, let's connect afterward and talk more about this.
Yeah, I also want to add, I mean, I think from the experience of that organizing effort, it's so, having gone from direct survivor advocacy for years and then into a policy space for the bulk of the past 5 years, there's a transition that happens in that. And it was really, for me, a lesson in humility and grounding and what it means when we occupy certain spaces, like this idea of this insider game and what is accessible to the public, right? There were times when we would be talking to legislators and having some of the conversations to advance some of the bills. And at the same time, there were the survivor organizers who are feeling a natural and understandable frustration of what's happening, what's going on. And I think it was very, very helpful and a real reminder of what it feels like to do policy advocacy with many of the necessary people at a table, and to right size transparency, information sharing at every turn, and really, really focusing on ensuring that everyone who's involved in this massive effort feels included and informed along the way. And that was a really, even as a survivor-led and focused advocacy organization, yet another reminder of how systems can leave certain voices out, right?
It was challenging also because imagine you're passing a bill, so we need to convince legislators from across the states. How do you do that? So I'm a member of our group, had a wonderful list of all the legislators where they stood. So we would kind of target certain legislators. We would try to have some regional meetings. Jane Doe again was so key because they had their contacts with all the domestic violence agencies across the state. So they gave us those connections. We do all kinds of things to reach, imagine to across the state. But again, we get so much done. We are working in a coalition, a broad coalition of getting the folks.
I'm going to switch gears a little bit, but I think it's a good continuation of this conversation. We're talking about expanding a broader understanding, or an understanding of the method of abuse, of intimate partner abuse that actually represents realities of survivors, right? And so often, I think, we talk about this at JDI all the time. Sometimes there is the idea of nuance and policy and law sometimes really don't mix well. And I would love, we have this wonderful piece of legislation now on the books. And there's a long road ahead in terms of implementation. And we have those who are entrusted with, as decision makers, as fact finders, who are going to be in a necessary position of having to apply some of that nuance and understanding. And I'd love to just hear from any of you. I'm going to start with you, Lisa, around what does it look like or mean to assess credibility? What does that look like in these more nuanced contexts? And how can anyone in this room or otherwise, what lessons can be learned from your experience with survivors?
Thank you. So, oops. So, yeah, credibility. Some of what I'm about to say comes from one of the hats I wear is I'm an expert witness, a forensic psychologist. In cases where intimate partner violence is at issue, and particularly, I don't know whether we'll talk about this later, but in New York, there's a relatively new statute that says that when intimate partner violence was part of the crime, sentences can potentially be reduced. So I work a lot with survivors who have killed their partners in the context of domestic violence, and often by the time an attorney would need me, it's because there's an issue of credibility of the survivor being disbelieved or discredited, doubted in court. And so just a few things I'll say about that is that I think most importantly, and this is for you all, when you talk to survivors in a context where you're going to be advocating for them, the very things that might cause a fact finder to consider a survivor not credible. Those things are exactly the same things that cause me to feel like there's a really good chance. This is an indication of truthfulness. And this is just, I have this knowledge to understand that. It's not necessarily intuitive, but I just wanted to run through a couple examples. One is that often when survivors tell their stories, and there are big, and you sort of alluded to this, there are big gaps in the narrative. And that can be because actually of memory gaps having to do with post-traumatic stress disorder, the nature of trauma. A majority of survivors have head injuries. For all of these reasons, they forget chunks. They also may focus on chunks of the story that an outsider might think are less important. And that is because, again, of the nature of trauma, when you're in the middle of a traumatic experience, your focus goes to sort of the detail that matters to you at that moment. It doesn't go to the date, the time, even the address and what happened yesterday. It might go to, is that door locked or unlocked? Because if it's unlocked, maybe I can make a run for it. So like a focus on the door and the details of the door, a focus on the child screaming in the other room. Is this person going to harm my child next? And so when they're telling the story, when they seem to focus a lot on peripheral details, even though that damages their story, which they probably understand. So that is an indication to me that they're telling the truth. That's how trauma works. There may be, and you sort of alluded to this too, a big sort of disjuncture between what they're saying and what the emotion they're showing in relation to it. So that can mean that they're very flat when they're talking about things that a judge might think they should be emotional about. Or they might be very emotional when they're describing something like the look, because that has so much meaning to them, even though it doesn't to the outsider, to the fact finder. So, that's just very important to notice whether they're positioning the story in a way that seems confusing to the outsider. Knowing that it's confusing to the outsider, that's an indication of their truth telling. The other thing is the content of their story. And here again, if you don't understand how both the harming partner and the larger world can collude to keep the person trapped, then their story doesn't make any sense. Why didn't you leave when you were alone in the house? And you easily could have. Nobody, you could have snuck out. There were no, locks on the doors. Well, if you understand coercive control, you know that would put your life in danger. And that person can find you. Why didn't you call the police? I'm sure that you all have talked in your classes and all over the place about why survivors, particularly marginalized survivors, would not choose to call the police for fear of putting their partner in danger or themselves in danger, for fear of being arrested in a sort of mutual arrest kind of situation. Especially this might be true, especially for same-sex partners. Getting, sort of, I don't think any undocumented person in this country right now is going to feel good about calling the police. So there's all kinds of reasons why people would choose not to call the police, that a established outsider, like a judge, would not necessarily have a lot of sophisticated understanding of. Why was the survivor seen laughing and flirting with her partner in the bar the day after presumably something very terrible happened? You know, showing a lack of understanding for what survivors have to do to accommodate their partners and placate their partners and keep themselves safe. If I'm with this partner at the bar, maybe I can control a little bit how much they drink. Or maybe I can time exactly when they turn and get them home right before that. Why did the survivor leave the kids alone with a partner, knowing that that was a dangerous thing to do, as if that person had a choice? So, I could go on, but I think this adds up to, there's no, when you don't have documentation and you don't have outsider voices, some of the ways you can look for evidence of a trauma response that indicate credibility when to the outsider, it indicates incredibility.
Can I add two things to that? One about the being in the bar. People still love each other. I mean, there's a what we call fierce entanglements, I think was this New York Times article. And I just thought that title was really, really good. This is somebody I love. This is somebody who's the parent of my child. And it's maybe you're gauging what's going to keep you safe, but maybe also saying maybe it's over. And maybe it's going to be better. And you can go back to that place where we were. People still love their abusers often. I often saw that in doing DCF work. Kids love their parents, even the ones who were really bad parents. People love them. And because I'm pumped stories about remembering things. I had a client once, it was a divorce. Husband was incredibly emotionally abusive over the years. He had alcoholic issues. But he had actually physically attacked his wife after a miscarriage. He forced her to have sexual relationships. And we brought that up in the trial. And she didn't tell me that for 6 months, representing her, but we did do it in the trial. Trial didn't go so well for a variety of reasons. And she said to me, well, maybe we should have brought up the sexual assault. And I said, well, we did, you testified. I said, no, I never testified to that. I actually got like the tape recording so that she could hear that she had. So this trauma changes your brain, it changes how you remember things. And it's the trial itself is traumatic. Everything that's happening to these survivors is traumatic.
I guess continuing with that conversation around the piece around nuance and actually the deeper understanding of these kinds of harms and dynamics, especially amidst a culture that is, really turning back the dial in so many ways around our interest and understanding of harm. When we're talking about, whether we're talking about second look clause, which I'm glad to jump into more as we've just filed the Survivor Justice Act legislation in Massachusetts that is actually looking at both pretrial and post-conviction relief. When we're looking at the learning curve, especially for judges, in understanding and recognizing the fullness of these kinds of harm. What are some lessons learned, recommendations, and I'm looking to you, Janie, to talk a little bit about what you've seen over your career in what helps and how we might approach that.
Yeah, so I'm muted. Yeah. I know there were many great judges and many judges are my friends. I've kind of given up on training for judges because you get some training and then you're on the bench every day and you're hearing terrible stories every day. You can see judges shutting down and then maybe they go to a training 2 years later and then remember that. We need to train better litigants as opposed to judges. Being able to work with survivors so that they can safely, both physically safely, but safely, emotionally safely tell their stories, I think is the most important thing. how can you articulate this? And it's difficult. And it's really difficult in a courtroom setting, because, you know, you have those stupid laws of evidence. That often don't actually even apply in probate and family court when the judge is doing stuff, but when he wants to stop something. How you are able to work with people to craft those stories. And that's why it's really important that people have advocates to work with them, and that they have lawyers. Even pro bono lawyers. In fact, some pro bono lawyers are the best lawyers there are. Because we hold the keys to the courtroom. And to expect a survivor to be able to go in and know what they're supposed to say, and how to say it in a way that it's relevant to your case, and what not to say. I spoke to the survivor once for 2 hours, and you know, sort of working on how she could raise things. And at the end of 2 hours, she said, I want to tell you something, and I want you to think about whether I should bring this up. And it was about her alien abduction in Florida. And it was like, no, I don't think you should bring that up, because I'm not sure, you know, and I certainly don't believe it was an alien abduction, but I believe she believes very firmly that it happened to her. And to be able to say, yes, this is your truth, but that's going to convince a judge that you're not credible, was really difficult to be able to do that. So I think part of it is figuring out how to craft these stories so that it fits into our very sort of rigid legal system.
And then they're up against the lawyer of the batterer, who, that's another bill that we just filed with the help of wonderful people here, is abusive litigation, where the survivor can leave the abuser and still be abused for years and years in the courts, and lose hundreds and thousands of dollars and continue to abuse. But what I experienced, that'll be a great lesson, is to go into family court, and usually, at least in Worcester, there's a court that deals with restraining orders. Go sit there, and that will really sober you. And then you'll see, how the judge deals, and then also the lawyer for the abuser, and how they continue to discredit the survivor and undermine it. It's very, very sad. So.
Looking at our time, I've been wondering whether we might want to cover some questions from all of you. And of course, panelists, as this would be to any panelist in particular, or to the whole panel. And please continue to share all the wisdom.
Sarah.
I'm he's very proud BC Law alum, class of 1995, and was very glad that my seat from first year was available. I sit here. What I'd love to hear, this conversation is, in some ways, has progressed so much from when I was sitting here. And the fact that there's a conversation like this happening is wonderful. So I guess my questions are, what are you most proud of? Like, what are the big, like how far have we gotten up the ladder? If that's right. And what do you think is gonna happen with this new administration? So hope and you?
I mean, it's interesting, when I talk to younger lawyers and advocates who, you know, say how terrible the system is, like, you don't know, you know. So I started practicing in 1978, before some of you were born. And I had started doing family law, not that I had any interest in it whatsoever, but there was no other woman in my area, lawyer, doing family law. And I've been doing it for about a year, and I had this, I thought, quite elderly woman, she's probably 5, come in and talk to me about her abusive situation. And her husband was a police officer. And 209A was relatively new. And not only I was practicing the town where I grew up, and it's not only a police officer, he was the police officer that had taught me bicycle safety in 3rd grade. And that just opened this world that I had no knowledge of. But the police never even responded to the calls. We'd go to court and nobody would believe her, and she was kind of hysterical and crazy because he'd driven her hysterical and crazy. And she just couldn't live on her own, and she ended up going back to, and that was like kind of devastating. We're much further along on that. You know, I think police officers who can really articulate domestic violence issues. But in some ways, we've gone backwards. And I think particularly in family court, there's more skepticism of women in the court. There's this wonderful article, oh, I can't remember its name, but how women are seen in family court as either whores or gold diggers. And this whole parental alienation issue, and that women are trying to get a, and I had a woman judge said, oh, they get restraining orders because we'll give them a leg up. And we sort of lost in the 80s and 90s, there were a number of very sad, high profile domestic violence and murders. And we saw some changes in the judges. There are still the same number of people being killed. You know, it comes out, we look at this, like 1 every 20 days in Massachusetts. They aren't getting the same media play, and I think the judges don't have the same understanding, and they're not kind of worried if they're going to be on the front page of the Boston Herald. So I think some things have gone backwards, and I'm not sure kind of how to address that, except I think this work around the track, Together Rising Above Coercion with the coalition of survivors, that when you actually got those survivor voices out, people listen. So thinking about how to do that in the media, it's a little tricky, but I think that may be how we bring attention.
I mean, I can jump in. Okay, so I think to bring that hope piece in around what do I feel most proud of? I mean, I think I spoke to this a little bit in my community lecture, but I think that the moment where we are able to also look with nuance at our own field and responsiveness has really shifted, I think, in the past, at very, very rapid shift, probably since 2020, but over the past several years. And it's interesting to think about, again, coming back to this conversation around nuance. You know, you have survivor advocacy organizations that are now holding and looking at what does it mean to actually support criminalized survivors. That was not that was not necessarily a conversation that was happening across the country 10, 15, 20 years ago. It was much more limited or sporadic, and certainly cases like the Framingham 8 and others would try to draw attention to that nuance, but I think there is more nuance. And so that is very exciting. And what is very concerning to me in this moment is, of course, the active rolling back of any kind of nuance. You know, we're fighting, I was telling you, but suddenly it goes from looking at, you know, how do we hold the both and how do we hold both survivors who want to utilize systems, but also survivors who want nothing to do with those systems. We're going from that to, there are even benefit systems, like what's going on? So to me, you know, we had a kind of a crisis room kind of call yesterday with our coalition membership. And, you know, we have just begun to do some of the repair of remembering who we need to be centering in the work, centering Black survivors, trans survivors, immigrant survivors, those who are most vulnerable, just started doing that work. And suddenly, those are buzzwords that we can't even include in our very fabric of our work. So I think it's going to be up to us to really, really move in good strategy about how we continue to keep this field resource, keep survivors with the resources they need, and not roll back our commitments to some of that more necessary support.
And I just want to say, as I get older, I'm forgetting names. That article that I referenced, there's an article that Lisa wrote with Deborah Epstein from DC. And it's really, if you read that along with the Joan Meyer article, together, it really shows you why. Where we're better is there is that research. You know, 20 years ago, nobody was doing any research into these issues. The research around brain trauma you know, and I'm able to give my lawyers trainings at Ellen Miller and Newton Wellesley to explain how your brain changes from trauma and how you can then explain that for the effect of traumatic brain injury, which we all hear about football players, but think about the domestic violence victim whose head's been slammed against the wall. There is research and there is science that we can bring into the field. A student here at BC did a research project on abusive litigation. That is sort of the, you know, what we're using in our legislation around that. And that is something that's hugely changed in, you know.
Yeah, and I just want to add, oops. I used to live in DC and worked with Deborah Epstein, who's a faculty member at Georgetown, on a research, we did a research project on what would happen in civil protection orders if you included the voice of the survivor and thinking about, I'm sorry, this was in criminal court. And when you listen to voices of survivors, there was then this great thing called no drop prosecution, presumably great thing, where we are going to prosecute the harming partner, whether or not the survivor wants it. Because who knows what the harming partner is saying to the survivor, forcing her to say she wants to drop the charges. So we're going to ignore her perspective. I'm using gender pronouns this way because that's the way it was. And so we did this brand new study called what happens if you, called victim informed prosecution. What happens, it was a program where we would have advocates listen to the survivor and bring the survivor's perspective into the prosecutor's office. That was considered shocking to listen to survivors, and it was, you know, involved training all of the lawyers in that U.S. Attorney's Office in DC, because that's where this work happened in DC. I go from then, that was in the early 90s, to now when there's this proliferation of deep clinics in law schools across the country devoted to intimate partner violence. You know, I work with a bunch in New York that are devoted to criminalized survivors in particular. That's amazing. And those are sort of armies of people, like you all, some of you, who will go out and be thinking about how the law needs to change when we begin listening very carefully to survivors. That's it.
We have two questions.
In terms of your point about nuance and criminalized survivors, I was wondering about how you strike a balance between, obviously wanting to acknowledge that these survivors who are in prison or dealing with issues with DCF because of things that have happened in their past and wanting to account for that as we move forward. Also considering that their abusers most likely were dealing with what were victims themselves at one point, and how you strike that balance between wanting to honor the past and the trauma that they experienced, but also wanting to protect their victims from any future harm, and just understanding that most people in our criminal justice system have endured some sort of trauma like that in their past. And of course, that informs their future decisions and their acts. But how do you strike that balance? It's such a difficult question. There's a lot of nuance there.
That is the question. It is incredibly hard to strike that balance. You know, I think it really depends on how you situate yourself in relationship to the role of incarceration in our communities, right? I mean, I think there is this piece where we look to prisons and jails as an as one mechanism, the primary mechanism we have to hold people accountable for the harm they've done. And there's a ton of data around there that prisons and those systems are not rehabilitative, right? And so what does that look like? And I think from our perspective, where we sit, we work with so many survivors who would not be alive but for those kinds of interventions, and some who are also deeply harmed because of those kinds of interventions. So it's the both and. You know, I think looking to, you know, I feel like sometimes this conversation is boiled down into, okay, are you abolitionist or are you not? And what is that? And I think even in the world of scholarship and thinking about what that looks like, we look at it as graduated steps. So where we come at this at JDI is, let's take a look at why many survivors are end up in criminal legal system interventions as defendants. What happens? What are those root causes? How can we best address some of those harms? And if there is a way in which we can mitigate the widening of the net of who ends up in those systems, that's where we start and where we focus. You know, I think that this conversation around what happens and how we address the realities of people who do cause harm is the next era of our work. Really, because we still have far too many programs and many aspects of this field that still, we're not doing the work of working with people who cause harm. And, you know, actually listening to a recent talk by Jacqueline Campbell, who's a leading thinker on domestic violence, fatalities and homicide, you know, her takeaway was, if we don't start working more holistically and systematically with people who cause harm, we're not getting at the heart of this problem. So many nuances to speak to. Glad to be in further conversation.
And the current better intervention programs are 40 weeks, 1.5 hour weeks. So one of the feedback we heard from DCF workers recently was it's hard to get some of the veterans to attend those. Plus it's going to be very cost prohibitive. So far they're more holistic, even though those are evidence-based, is a good reason for them. But you know, we have to look at other approaches for, I mean, just as much as looking at the victims, also looking at the perpetrators and how do we address their needs too.
Yeah, just one more thought on that. So better intervention is a common, punishment for people who harm and criminal conflict, and that's it. You know, go to better intervention, you're good, as opposed to jail time or anything else. And I think until relatively recently, the norm for better intervention programs, I mean, often they have to comply with a certain set of standards for how they work in order to get funding. They were very much about hitting people over the head, to use a problematic metaphor, just to get people to say they were wrong, they were bad, they are holding themselves accountable, and they will change. That was sort of standard, calling each other out on your crap. And I think the research on those kinds of interventions is actually really mixed. And even more mixed, the more marginalized the person is, the more mixed the poor research is. But there were, just to piggyback to what you were saying, Hema, about this, the next wave of sort of thinking and innovation has already begun, where there are really amazing innovations in how we work with harming partners. They're very culturally specific, oppression aware, and come at harming partners who are also survivors, as you said, from the perspective of what happened to you. And how can we support you to be the person you want to be anyway? And often it's done through the lens of fatherhood. You know, this is not the dad you want to be modeling for your kids. And so I think that is another thing to be hopeful about, is that there's really a growing awareness that we need to hold people. That's why we use phrases like people who harm instead of perpetrators, to recognize that, and also, criminalized survivors have often done really bad things, to sort of make clear that we are all capable of harm and capable of being and sometimes victims. So.
I think I want to leave space for additional student questions. I know we have a question about any other student.
And I was going, I'm curious in regards to the legal landscape in terms of prevention, all eyes are on strangulation. And California is doing a lot of work in regards to that. It's not quite and all those who have murdered. Percent of them have been on the board strangulation. And so I'm curious with strangulation in mind. Where do you see the legal landscape in Massachusetts addressing regulation on abortion function?
That's really important because what you cited and also the Jacqueline Campbell work on ranking risk assessments for fatality strangulation is one of the biggest red flags for that. Why is it? I think we've gotten people to stop calling it choking, which seems so much less than strangulation, and we do have as a I'm losing the word, but a factor to enhance a crime, the strangulation specifically called out in our criminal statutes. But I don't really know how it's being implemented in the field. It's not a review.
We sit on a high-risk subcommittee of the Governor's Council Against Sexual Assault, Domestic Violence, and Human Trafficking. And, you know, in that strangulation, the conversation comes up a lot. You know, one of the issues is actually screening, adequate screening, and consistency in screening across the law. You know, there are, you know, we are in a state where you can't, the practices between from one police station to another are so vastly different. And that has really, I mean, there are some amazing tools out there. There is a questionnaire. There are, you know, Jeannie Geiger Crisis, the Geiger Institute is a leading JDO member and a leading voice in this kind of work. And there is a lack of consistency and practice in actually doing timely screenings and understanding of the existence of and impact of strangulation. You know, from our perspective, we do a lot of the advocate education around this work, and I think many of us have been at trainings in the past of building that. There is legislation that was just filed that does create a technical fix. I don't have it top of mind to our current definition of strangulation that would actually more accurately represent what the actual harm is. It was fairly outdated, so.
Yeah, I mean, every police station has its own, every district attorney is different. The attorney general is not in control of the district attorneys. You know, attorney general can't say you're gonna do this. Every court was supposedly a unified court system, but really not. Every court's an individual system. So consistency is totally lacking in Massachusetts.
That, no.
I know.
So you want to end on that?
I don't know.
Can we end on a slightly better note?
Oh, yeah, well, my other thing is we target change in Massachusetts, because if they didn't do it in John Adams' time, why would we do it now? I'm not sure that's any better.
Well, I want to thank
Just the good note is survivors are getting organized.
Yes.
Survivors are getting organized, and that's what happened in Connecticut. There's a group of survivors with the help of some agencies, but that's the good news.
That is good news. Thank you. All right, I wanted to thank our panelists. This has been a fantastic panel, and thank you for reminding us and enlightening us and doing it with due regard for the complexities and the nuances of this is extremely important and extremely difficult work. I hope students will find other ways to get involved. Hema's going to be here for a little while longer as our senior fellow. She's available to people who want to talk. I'm hoping that our panelists, we unfortunately have to vacate the room because there's another class. It's going to come in a few minutes, but maybe if the panelists could engage with people in the hallway, if people are interested in talking one-on-one, that's a big part of what we do. But I just want to thank you one more time. This is really appreciated. I'm going to use the program, you check our website. We have a panel coming up about emergency room care. We have a number of interesting programs. So thanks to Lissy and to Amanda and Abby for organizing this, and thanks to our panels, and thanks to all of you.